Introduce yourself.
Yeah, hi, I'm Sheema Choudhury. I'm an attorney at Gehi and Associates. And yeah, that's my introduction.
Oh, don't sell yourself short. Sheema is by far our most experienced attorney. She's been doing this for a long time. She is especially adept to helping clients with criminal issues in their immigration cases. She also works in family law, child custody. She's an excellent divorce attorney as well. Why I discussed this last time with Sade, where my focus is primarily immigration. Gehi and Associates has a wide variety of incredible attorneys that are well equipped to handle many legal issues, and Sheema is one of them. So welcome to the show, Sheema.
Thank you, Greg.
Okay. So Sheema, which office are you located at?
I'm in the Jackson Heights office.
Okay.
We're on 7409 37th Avenue, one block from the big train station, 74th and Roosevelt. Yeah.
In Jackson Heights, and you can see
Jackson
the
Heights.
numbers right here. Okay, so Sade is primary. You do a great job being a trial attorney for immigration cases as well as for USCIS. So on today's show, we wanted, like I said earlier, we kind of wanted to discuss issues regarding criminal convictions or arrests and the effect they have on an immigrant in general. What will prevent you from getting a green card? What would prevent you from getting deported? What is inadmissibility versus removability? And those kind of topics. Now, I thought we'd start off with an easy one. After you become a naturalized US citizen, are there any crimes you can commit that would get you deported?
So generally, once you become naturalized, if you commit a crime, you just have to deal with it on a statewide level. However, you're basically that's a general rule. Yes.
So once you become a US citizen, and this is why we encourage people to naturalize, is because once you're a US citizen, if you commit a crime, you're not going to get deported. Okay, it's the only way you could get deported is if it's something through what's called denaturalization. And that is for two reasons. You can be denaturalized because you lied about having committed a crime and for committing the crime itself. Okay, so after you're naturalized, the only way you could be deported is for not being honest and committing a crime before your naturalization. After you're naturalized, you're safe. I mean, you're still, can be punished and convicted in the United States, but you don't have any risk to your U.S. citizen status. Okay. So I think we can start with what prevents you from being admissible into the country. What would prevent you from being allowed to come into the country with a green card? Sorry, go on.
So generally, you want to apply for a green card. Number one, there are a certain number of types of crimes that will make you ineligible for a green card. Number one is aggravated felony. So that's a big no-no. That is not going to make you eligible for a green card. And what is an aggravated felony? It's usually it's like the bigger crimes, like generally drug trafficking or any involvement in drugs, with some exceptions, will be an AF, aggravated felony. We're talking about murder, sex abuse, rape, child porn, bribery, firearms trafficking, violent crimes with a jail sentence of at least 1 year, fraud exceeding 10,000. So generally, those are the big crimes.
Okay, so you said something that was interesting, over $10,000.
Yes.
Are there any bright line issues that would, such as amount of jail time or monetarily, like with money, that would just be a obvious red flag?
So with money, like the money laundering and the fraud, generally the red flag is over 10,000. So you might not have served jail time, but if you were convicted of a statute that said the fraud was over 10,000, that's an AF.
That's an AF.
Yeah,
Oh,
that's an AF.
all right. So, and there's also, so besides aggravated felonies, which can make you inadmissible and deportable,
Yes,
crimes involving moral turpitude. Okay.
right.
So how do these play a part with, in the immigration process?
Okay, so generally, so if you can basically, if you're convicted of a crime of involving moral turpitude, that may also get make you ineligible for a green card or make you deportable. Usually, deportation occurs if there's two or more convictions of crimes involving moral turpitude, or a single conviction of a crime involving moral turpitude within 5 years of entering the U.S. that results in a sentence greater than 1 year.
Yes. Yeah. So that's a good. So one of the things we look at is have they been, or, were they sentenced to over a year? Because there's some crimes you can if you commit them, you're convicted, but you're sentenced to less than a year, you can be okay. It won't have it won't have an effect on you. But if there's some things you can do on your own. If you have a criminal background, please get an attorney. We see many people come into this office. They filed for citizenship on their own or a green card on their own, and they did not understand their criminal record. And before they know it, their application is denied. And then to add insult to injury, they're sent into immigration court, which is removal proceedings. That's where you can be deported. And once we get there, it's very difficult to repair. But we do it all the time. But we strongly recommend you get an attorney, because with a criminal record, you could be referred to immigration court. There are things that we could do. One of them is we can argue the petty offense exception, which is if the crime was punishable for less than a year and you only served 6 months, this is called the petty offense exception to a crime involving moral turpitude. Okay, drugs are a huge issue we see. We see it quite frequently. If you're arrested for anything over 30 grams of marijuana for any other drug, it's a deportability issue. Okay, so what we are able to argue at times and have had success with depends on the way the conviction is worded. Sometimes someone will be arrested and it'll just say controlled substance violation. It doesn't state specifically what the controlled substance was. We can sometimes that can make them safe, okay, because they weren't, if they're arrested for crack cocaine or heroin, then it's a different issue.
Well, generally, just to let the viewers know, drugs are a big no-no for immigration. Yes. They're pretty conservative when it comes to any kind of drug conviction. So you have to be careful. Like, even you might think like, oh, I have possession of marijuana. I'll be okay. That's not an AF. That's not going to make me deportable. You'd be surprised. Okay. So we do have a question.
Okay, great.
I was convicted with 30.5 grams of marijuana. Does that come under the relevant drug crime? What should be the next step to apply for my green card? So, Greg, do you want to answer that question?
So if you're So this is considered, because it's just over 30 grams, it's considered a drug crime. This is a big no-no, and it'll make you inadmissible and deportable. So what we would do, and this is what Sheema does, is we do what's called post-conviction relief. Now, it's sometimes difficult in drug cases, but considering this case just over 30 grams, we can reopen the case through post-conviction relief. In New York, it's called a 440 motion, okay? And we'll go to the ADA or the DA, district attorney, and ask them to reopen this case because of the immigration effects it had on them. We're able to, the first thing we do is we request a transcript of the criminal record, that's everything that happened in court, and analyze to see whether they were informed, the client, the immigrant, was informed of the criminal consequences of, for example, pleading guilty. If they were not informed of these consequences and they pled guilty, we can reopen the case, discuss this with the DA, and hopefully get it, whatever they were convicted of, reduced to under 30 grams of marijuana. And so they can apply for a green card. All right? Okay. So other things we look out for: firearms. That's anything involving a firearm is quite a big issue. Like you said, drugs, firearms, also domestic violence. If you have an assault charge or a battery charge against another individual, and that individual is your spouse or what's called a similarly situated person, could be a boyfriend or girlfriend that you live with, then it is bumped up to a crime involving moral turpitude and is a removable offense. All right. Anything you'd like to add, Sheema?
Yes, I mean, usually with domestic violence, it's taken seriously. Of course, it's a terrible thing. I mean, it can definitely be a CIMT. So you have to be careful. Like for example, there's crimes of domestic violence that are also CIMTs, are like sexual battery, child abuse, rape. So you have to be careful. Also, it's really looked down upon. So when you are applying, I have seen this in a couple cases, it may not be an AF, but the officer will look at it as a matter of discretion. USCIS and the EOIR has the leeway to deny applications as a matter of discretion, because you still have to have good moral character, and they might see that as you not having good moral character.
Yeah, I'm glad you brought that up, Sheema.
Yeah.
So discretion comes into play in not only when it's a gray area, but just in general. I mean, you will see a wide variety, like we see a wide variety of cases. Some people with the same crime have different, there's different outcomes in their cases. And we try and help them with this. But some examples with discretion we see is, well, they only have one conviction, but they were arrested many, 10, 20 times. And the officer or the judge or ICE, DHS, they'll look at this and they'll say, well, they have one conviction. It's not a deportable offense. It's not a crime involving moral turpitude, but they've been arrested 17 times. So they'll exercise their discretion and they'll deny it. So, something that we do, and the reason you should get an attorney is because we'll help you explain what's going on. We'll draft a memo, we'll research the issue, and appeal it if necessary, we don't have a positive outcome. Okay. So we've covered a lot so far, and kind of, went, back and forth. Another thing I would like to bring up before we go back is DACA. Now, we all know what DACA is, the Dreamers. When DACA was passed by the Obama administration, I believe it was, they created a whole new category called significant felony or significant misdemeanor. Excuse me, I apologize. Significant misdemeanor. So with this, created a whole new set of rules that we need to go through. Okay, so and we have many clients that they have DACA, they've been living here their entire lives, and they will be arrested for something they think is quite minor, but it ends up making them removable from the country. Some of this is, this is again domestic violence, any like robbery, small amounts of drugs even, and what we see most of the time is DUI. We have driving under the influence. We had, and that can get a DACA recipient deported. So DACA, there's a much higher standard. We had one client who was arrested for drunk driving, and if he was convicted of this, he would have had his DACA status, or DACA is not status, but he would have had his DACA revoked. Working with a criminal attorney, he ended up pleading to a more significant traffic violation, reckless driving, and he had to spend a week in jail. But the drunk driving was kept off the record, and that allowed him to keep his DACA. So this is where it gets kind of confusing. He was arrested for drunk driving, something that he would not have had to go to jail for. I mean, he would have had his license revoked. There are other serious consequences, but he would not have had to spend a day in jail. But because of his DACA status, he pled to reckless driving, had to spend a week in jail, but could keep his DACA. Okay, so this is how it gets complicated, quite quickly. Why would someone want to plead guilty to a more serious crime and go to jail? These are the choices we have. It becomes difficult sometimes.
Okay, so I see another question. How do I answer the criminal history portion of my green card application? Okay, so we would recommend that, you seek counsel, because that can be very complicated to answer. And we have done countless green card applications for clients who have a criminal record. And, Gehi and Associates is very experienced in how to do this. For example, a lot of clients who may not have any idea of how to answer these questions, it asks, have you ever been arrested? And they may think, yeah, I was arrested, but the charges were dismissed. So then they mark no. And then they go to the interview, and then the officer is like, oh, have you ever been arrested? And they're like, no, I've never been arrested. And then the officer said, oh, no, I have record that you were arrested on this date for this. Oh, yeah. And then you say, oh, the charges were dismissed. No, now the officer can say, you're lying to me. You lied in your green card application because you were arrested, even though the charges, I've seen this type of problem many times. So it's better to get it's your case, it's your life. You should seek counsel. And we can be reached at we have 3 offices, and we have basically my office is in Jackson Heights, like I mentioned before, and our number is 718-263-5999. And also, if you want to email us, the email is info@gehilaw.com. So basically, you should seek counsel, because that's very complicated.
Yes, it can get very complicated very, very quickly. Okay, so and another thing I just want to add on to what Sheema was saying, please tell your attorney everything. Okay, what Sheema said was quite accurate. Clients will come in and they'll say, I was arrested, but it was dismissed. I was not guilty. Why would I need to bring that up? The Department of Homeland Security and USCIS know. Okay, so there's nothing worse than going to an interview and your attorney being blindsided by the fact, because you didn't mention you were arrested. We can take care of it. We can help you, but please tell us in advance. All right. Okay. So any other questions?
I see another question. I had a criminal conviction in Brazil right before I enter the US. Will that impact my green card application in the US? Okay. So that's another reason why you should seek out an attorney. Because people may think, oh, well, that was in a different country. I'm in the US, so that shouldn't count, but you would be surprised. That's very complicated, and we've handled this type of case, these types of cases many times at Gehi and Associates, and we would, help you.
Yes. Okay. So we discussed post-conviction relief if the crime is serious. We've discussed crimes involving moral turpitude, aggravated felonies, significant misdemeanors, and there is one left. Well, there's many left, but another is the bars to asylum. This is an asylum applicant, and they created a whole new category called particularly serious crime. Now, what does this mean? Well, it's an aggravated felony, but it could also be other things. It could be anything involving violence or like we said, drugs. It could be a variety of things that the court will analyze and reach a decision on. If the crime was purely, if you're an asylum applicant and in your home country, you were convicted of a purely political crime, then it doesn't apply. Then you're safe. So if you were arrested and sent to jail for, I'm just making the, just for speaking out against the government, and they sent you to jail for a freedom of speech violation, this would not affect your asylum case. We also have, I think I discussed this a couple weeks ago. We had an applicant who was arrested several times by her government for political reasons, and they made up these charges. I believe they accused her of running a brothel, and this was, she was a women's rights activist in a country that did not allow that, and they accused her of running a brothel, and we were able to prove it in court, and the judge agreed that this, if convicted of, was if she did this crime, it may bar her, but because this was a purely political issue, that she was safe to apply for asylum. Okay. What is the next question? When can I take a waiver of inadmissibility? That be the 601 waiver?
Yes. So there are certain crimes that can be waived by that waiver.
Okay. What are those crimes? Because I don't remember them, so I'm putting you on.
Okay, that's okay. So, basically, you can use a 601A for certain number of crimes that are listed. You should definitely seek, if you want to do a 601 waiver. We have done this again many times at Gehi and Associates. And I would never, if you have a criminal record and are trying to get a waiver, I would not recommend that you do it on your own. There's a lot of crimes that are covered. There are a number of crimes that are covered for the 601, but I'm just going to go over a few that are not covered. for example, it's not available for all crime-related grounds of inadmissibility. For example, not controlled substance violations, usually controlled substance traffickers, human trafficking, money laundering, other crimes that you may be able to seek the waiver are, for example, crimes involving moral turpitude. You could get a waiver for that. Another crime is, so basically, I'm basically it's complicated, but that's why you should seek counsel.
Yes. So like I said, you're deportable if you commit a crime involving moral turpitude within 5 years of being admitted to the country.
Right.
What if you had a green card for 15 years and you commit a crime involving moral turpitude? Would that make you deportable?
Yes, it could make you deportable. Yes.
Depending on the crime.
Depending on the crime, yes.
Sometimes it's not, sometimes it is. If you go to apply for your citizenship, there are conditional bars for a 5-year statutory period. So if you commit a crime involving moral, say you've been here for 15 years, you commit a crime involving moral turpitude, say any one of them, and you apply for your citizenship, it can be denied because it was within 5 years, because you applied for citizenship within 5 years of that. So what we advise the clients to do is wait another 5 years and then show evidence of good moral character. Believe we went through this earlier, but there's, when you fill out, your immigration forms and you're applying for a green card, this word comes up all the time: good moral character. How is that defined? And the answer is it's not. It's not defined. It is, well, or you could say it's negatively defined, where it is defined as what is not good moral character. And committing crimes will prove that you do not have it.
Okay, so I see another question. I was physically indulged with a partner who was below the age of consent. Will that amount to an automatic bar for me to apply for citizenship? I have a green card for 12 years now. So I'm thinking that this person is talking about statutory rape. Greg, do you see that?
I believe that.
So rape is a big it's an AF. So that most likely would be an automatic bar for citizenship.
Yes.
If you were convicted, you pled guilty, that's generally an AF, yes.
Yeah.
I see another question. How will USCIS check my criminal records in the green card application process? Well, that's why when you apply for a green card for naturalization, you get a biometrics notice. You get your biometrics done, which is your fingerprints, and the government will run your fingerprints in their database and determine if you have a criminal record. Am I correct, Greg?
Yes, that's exactly how they do it. You have what's called a biometrics appointment, and they will do a nationwide background check to see if you were arrested at all or ever. And trust me, they will know. They will find out.
Yes, they have very sophisticated database. So
they will know.
They will find out. Yeah, so you can't hide it.
Okay. So just to reiterate our disclaimer: past results do not guarantee future results. This is attorney advertising. It's meant to be informative, educational, but this is not legal advice. Please, if you would like legal advice, we're happy to talk to you, especially with criminal issues. Please get an attorney. Like, as we discussed, it could get complicated very quickly, and you could land yourself in hot water before you know it. And it's hard. I mean, we have a couple cases. We have clients come to us after they've tried on their own, and it's hard to fix things in the end game, so to speak. We can, early on, we can try. You can, if you're arrested for something, and you're not in immigration court, there's a whole, we have a whole box of tools. As we discussed, post-conviction relief, waivers. There's a whole, we have a whole bunch of tools. Last minute, our choices are narrowed down. Okay, it makes things very difficult. And if you're in removal proceedings, it also affects your chances of receiving prosecutorial discretion, which was last week's episode. If I see this all the time, people are in removal proceedings and their case would otherwise be dismissed, but they have an arrest, and Department of Homeland Security becomes reluctant to dismiss their case. I mean, Sheema and I have several cases where clients have minor arrests, and everything has to, takes longer. If you're in removal proceedings, and the government's trying to deport you, one option for relief is for you to adjust your status through a family member. We discussed this last week. So if you're married to a U.S. citizen, but you're in removal proceedings, the fastest, most effective thing to do is show Department of Homeland Security a marriage license and a pending or approved petition through a U.S. citizen spouse, right? Normally that'll get the case dismissed from court very quickly. But if you have a criminal record, the process takes longer. Right now we have several cases where the easiest thing to do is just to get the case dismissed, and they could apply for their green card within USCIS. However, they have a criminal record, and Department of Homeland Security is requesting that we do it all through court. So this whole, green card application that you normally just have an interview for, and fill it, you submit the forms, evidence, and you go to an interview. This whole thing has to be done at a trial. And it becomes, it takes longer, it makes things more difficult, and you have to be much more, careful. Okay. Any other questions? If I am in immigration detention under the custody of ICE, how will this affect it? Okay, so if it depends on which state you live in. Sheema and I could talk about this at length with many clients. We're in this position. In New York, the New York police are unlikely to refer your case to immigration, okay, or what is now Department of Homeland Security. They're unlikely to. But if you live in Pennsylvania, we see a lot in Georgia and Florida, right, Sheema?
Yeah, the more conservative, New York is very liberal, very diverse. New York City, I'm talking about. So the NYPD is reluctant to, share your immigration status as well as a lot of other government agencies in New York City with the government. But however, that is not the case for the rest of the United States.
Yes, so they will, like in Pennsylvania, we see a lot of clients that are arrested for relatively minor, jaywalking. And the police will check their immigration status and refer them to the Department of Homeland Security, who detains them after they pay their fine or serve a day in jail, and will detain them, and you'll have to have a bond hearing and show that they're not a danger to society. Show that they can be released on their own recognizance until their immigration court proceedings have concluded. This is one way to get in immigration court, is getting arrested. In New York, like we said, it's unlikely. but we see a lot of cases from, you know, if you're an immigrant without status in Georgia or Pennsylvania, you get arrested, they're likely to send you, you know, after you're done with the state police, they're going to send you to immigration. And, you know, so this issue. So we'll have a bond hearing. We have to show relief. You'll have to post a bond. You know, this could be anywhere from $5,000 to $20,000. It could be more. You know, depending. You have to show ties to the United States. You know, it becomes very, very difficult. But we do it. You know, bond hearing. You know, we do bond hearings. We can, you know, help. You know, even with a lot of these cases, the charges will be dismissed, but you're still in immigration court. So the criminal court, they'll say, oh, he didn't do this, or this is not, you know, not worth their time. And they'll dismiss it, but you're still stuck in immigration court. Right?
Yes. I mean, that's generally true because if you go to other parts of the country besides New York City, they're pretty conservative. So that's generally true. You have to be careful. Yeah.
You know, this kind of, you know, there's this term sanctuary city.
Yeah.
It's not really defined, or sanctuary state. And nobody knows what this, you know, the real definition is. But one of the issues is the local police policy to refer you to Department of Homeland Security. And, you know, many states, they just don't check. It's not their business if you're a US citizen or not, because it's a local matter, not a federal. But other states, they refer you to the feds. Right.
All right. I have another question. I don't know how much more time we have, Greg. Do we have more time? We can do one more question. Okay. Does your firm help to pull out criminal records before applying for the green card? Yeah. So when you hire us, we go over the entire green card application with you. And then we will ask you the questions about your criminal record. And yes, we will help you obtain the criminal dispositions. We will tell you how to obtain them. So yes, we help. We definitely help. Yes.
Yeah, and we'll I mean, that's what you're paying for. Is an attorney who's been through this many times to do a full review. And we'll analyze your case, and we'll present your options to you. Some, you know, and a lot of the times we can help. I mean, I would say most of the time we can find, by hook or by crook, we can fix this. You know, and even in cases where it seems very difficult, post-conviction relief. We go back to criminal court, and we will do our best to get your conviction either dismissed or pled down to a less significant charge. Okay. So I see another question. I would like to do a consultation, but I am in Miami. That is not a problem. As long as an attorney is licensed in any state, they can practice you can be licensed in Nebraska. You can practice immigration law in any state in the country. That's it. I mean, you couldn't do local criminal law, but you could practice immigration law in any part of the country. So say you're in Miami, call us up. We'll do a Zoom consult. We'll tell you what your options are. You know, explain what our opinion would be, how you can retain us. And even if it involves a local issue, we would consult with, and this is something we do all the time. We work with other attorneys at other law firms, criminal defense attorneys in different states, family attorneys in different states, and we can, and we will, work with them, or if we could do it all in-house, we do it all in-house. All right, so please come to Gehi and Associates. We offer free case evaluations. You can go to Jackson Heights, talk to Sheema. She has a wealth of knowledge and experience. She's very good with these things, especially 440 motions, post-conviction relief. And consultations are free. 15 minutes, come in, we'll talk to you. You pay nothing. And we'll see, we'll do our best to help you out. I'm located in Ozone Park. So again, I think it's the lowest one. Call me up. I'm right here. I'm in the office right now. You can come in, talk to us, Sheema or I. Last week we had on Sade. She's fantastic. The week prior, we had on Soraya. She's another fantastic attorney. She's the lead attorney of all of our law firms. So we hope to see you in. Okay?
Okay, thank you.
All right, thank you. See you next week on Green Card with Gehi.